Our topic will be preserving testimony. It is the penultimate recording of this chapter 1 of our course, Witness Prep. Let's get going. Now, first, a few commandments before we proceed. When examining a witness, never ask questions that you have no idea how the witness will answer. You can prepare your witness. You can discuss with them during an interview, for example, or just generally during DMs. Okay, what will the testimony encompass? What do you, as a lawyer, expect from them? What does the judge expect from the witness? What can the witness testify about, etc.? The most important part here is that you do not coach the witness to answer in a specific way, unless, of course, you're following a judge's order. But what you can also do to ensure your knowledge of a witness answer to a question is preserve their prior testimony. And that can be done through a deposition. And if there's a surprise at the trial, so oops, the witness contradicts themselves, oh, okay, now you have their prior statement. So now you're prepared to combat or to redirect, to clarify on something. But wait, knowing the answer isn't enough. So simply knowing how the witness would answer. You have to be ready to prove this answer to be correct, or at least show a contradiction. So yeah, while you can have a nice deposition, so a nice preparation of the testimony, it's it's a shame, but it's too bad if the witness contradicts themselves at the trial. So what are you gonna do? You had this nice little preparation, but oops, witness says something completely different at the trial. And that's what we're going to focus about, how you can deal with that. Your primary tools for obtaining testimony, for preserving testimony, um, are depositions. They can be expensive, but they can pack quite a punch. Expensive as in time consuming, not necessarily financially expensive. Financially expensive, expenses are a topic for real life court, probably. I don't really think there's gonna be huge expenses in a Roblox court. But basically, you have an oral deposition where you, so the lawyer, the adverse lawyer, so the lawyer of the opponent, the deponent, so the person who's being deposed, so who's gonna testify, and a court reporter all gather up in a group DM, more often a group DM than some hearing, and it's basically like an examination, but it's not done in court. So depositions are usually done outside of court. And then there's a written deposition where lawyers first submit a set of questions, so they're prepared, and they can only ask from that set of questions. Now, of course, the scope of what you can ask is limited by that, because you can't follow up with a line of questioning, so you have to stick with your questions. But yeah, it's also a tool, although used rarely. However, depositions are done out of court, so wouldn't they normally be hearsay evidence? So why even bother making them? Well, there's a hearsay exception called prior inconsistent statement. Basically, the hearsay exception of prior inconsistent statement says that even if the evidence was obtained out of court, so even if the evidence is, well, basically out of court, you can introduce it if it shows a witness inconsistencies in their testimony, for example. So when in the past they testified inconsistently with what they're telling you now. For example, say there is a car crash, and say the car crash happened at an intersection where two cars collide, and basically everything depends on a traffic light, for whom the traffic light was red and for whom it was green. So basically, who passed the red light. And at the deposition, your witness testifies, yeah, the light was green for car A and red for car B. But wait, oops, at trial they say the complete opposite. They say, nah, the light wasn't green for car A, it was red. And in that case, you can impeach their credibility by showing their inconsistent statement. You have prepared the deposition, and now they're saying something completely different. And you can point out this inconsistency in court during the trial by pulling off something that is known as an impeachment by contradiction. First, you would lock in their answer that they gave at the examination at the trial. How can you be so certain, for example, that the light was red for car A? So, are you sure that's the case? Do you want to reconsider that kind of stuff? Then lock in that answer. Hand them the deposition. I'm gonna hand you this copy of our deposition. Obviously, you were under oath, right? That kind of stuff. And then make the witness read their prior statement. Could you please read this line you testified? And that's it. The witness is forced to contradict themselves by their own words. And that most often shatters any credibility. Of course, there are drawbacks to putting on this show. Now, if things work out gladly, yup, you've completely destroyed the witness credibility. Glad you made that deposition, huh? But in some cases, depositions might not even be necessary and can be outweighed by the costs. For example, who's going to pay for everyone traveling to the venue of the deposition? This is not so much the case on Roblox because we're doing group DMs, so it's not, travel costs aren't a big deal. But coordinating can be stressful. You have to have a court reporter with you, so if you can prepare with your witness at home, why would you bother pitting them in this group DM? That's kind of unnecessary. Besides, interrogatories can preserve some testimony too. Interrogatories are a set of questions that one party files for the other one to answer. Ultimately, it's up to the lawyer to decide. Depositions are a method to pin down vital facts. If you don't trust your own witnesses, which I hope you do, but if things come this far, um, you might want to consider pinning down their statements so that they cannot go back down at the trial. Besides, interrogatories only work for party to parties, so you cannot send an interrogatory to a witness. You have to send it to the other party. So, for example, plaintiff sends interrogatory to defendant, and defendant has to answer, and vice versa. But it only goes party to party. It doesn't. Interrogatories aren't applicable to witnesses, so third parties. Besides, you can depose opposing witnesses. That's one of the common purposes for deposing witnesses, because with your own witness you more or less know what they're going to talk about. But how will you know what the opposing witnesses will testify about? You can depose them just as easily as you will be able to depose your own witnesses. It's kind of up to the lawyer. What do you want to achieve by deposing the witness? Do you want to perhaps pin down a crafty witness that could back down at the trial? Or do you want to just have this foolproof, fail safe guarantee? Yeah, even if this happens? Or do you simply want to prepare your witness? It's kind of up to you to decide based on your case, what do you hope to achieve by deposing, and is it necessary to depose to achieve this goal? That's it. That's all there was to preserving testimony. Next up is going to be the Brady Rule.